Welcome everybody to this Gatehouse Chambers brew. I hope you've got your cup of tea or coffee ready. You are welcome to have your camera turned off if you want to, if you're working from home, and that's fine. Want to be checking your emails as they come in, or having a cup of tea, or dunking your biscuits. We don't mind at all. This is an update on the Animals Act by Emma Woods and Henry Slack, who are in the team here at Gatehouse. If I say Hardwick, because I sometimes slip into saying Hardwick, I'm sure you'll all forgive me. We are updating you on recent Animals Act cases and points that you may have missed. I'm sure you're all here listening because you currently have Animals Act cases, or it's something that you regularly do for both claimants and defendants. And there's something in this next half an hour for both of you, whether you're a claimant or whether you're a defendant, as to some of the intricacies of the Animals Act. This isn't meant to be in-depth analysis of all aspects of the Animals Act. My talk on that normally takes 3 hours. This is just an update on some specific points to watch and recent cases. So Emma is going to be talking about Section 22A, the start of the statutory test in the Animals Act for non-dangerous animals. I'll be dealing with the last stage of it, which is sometimes overlooked because everyone's run out of steam by the time they get to the last stage of the statutory test. And Henry Slack will be looking at some specific cases of riding accidents and also some of the statutory defences. Don't worry about scribbling down case names, references as we go along, because after today we will email out to you all a takeaway cup with just some of the main points of each of our talks, but also those references of the cases that we refer to, so that you'll have that in your fingertips. If you have any questions, save them up till the end, and then we'll try and answer your questions at that time. So first of all, I'm going to introduce Emma Woods, who's going to talk to us about what's been happening with regards to Section 22A, the first part of the statutory test in the Animals Act. Emma.
Thank you, Jasmine. So the first hurdle in the statutory test in Section 2, subsection 2, regarding liability for animals which do not belong to a dangerous species is subsection A. Now, that section requires that damages of a kind which the animal, unless restrained, was likely to cause, or which, if caused by the animal, was likely to be severe. Now, essentially, there are two alternative limbs under A. Firstly, the animal, unless restrained or restricted, was likely to cause this kind of damage. Or secondly, if the animal caused damage, it was likely to be severe. Now, in this brew, we're looking at the second limb, severe injury. Likely or likelihood is being defined as to be reasonably expected. This is by the House of Lords in Merthyr, and also by the Court of Appeal more recently in 2008 in Freeman and Higher Park. And this definition was considered to be settled by Lord Justice Maurice Kay in Turnbull and Warriner in 2012 in the Court of Appeal. Damage is defined in Section 11 of the Animals Act of 1971, but it's always useful to go back to the wording of the Act itself. Now, that section defines damage as the death of or injury to any person, including any disease and any impairment of physical or mental condition. Lord Justice Lewison in Turnbull and Warriner noted that previous decisions in horse riding cases on the question of likelihood of severe injury were statements of fact rather than rulings on the law. You notice there have been inconsistent decisions on this. Now, the likelihood of severe injury is currently viewed as to be a matter of evidence. The defendants in Couplin and Jane Allison Equestrian Limited in 2013, and also in Lynch and Ed Walker Racing Limited in 2017, successfully argued it could not reasonably be expected that severe injury would follow. Now, both of those cases involved horse riding accidents. There's been quite a lot of cases about horse riding accidents, but also there's been some cases about dog strikes. In Hunt and Wallace in 1991, the claimant was injured at a farm as a result of a border collie running into the claimant. Mr. Justice Pill found that Section 22A was satisfied. If damage was caused, given the comparatively large and potentially fast-moving dog, damage was likely to be severe. There's been a more recent case earlier this year. In Menzies and Doggy Daycare in Winchester County Court in January of this year, the claimant was out for a walk with her own dog in the Ulver Valley Country Park, where she was knocked over by a golden retriever, Lottie, who was being walked by a dog walking service. And the claimant unfortunately fractured her hip. In an extemporary judgment, His Honour Judge Berkeley dismissed the claim. In respect of section 2.2a and the limb that if Lottie caused damage, it was likely to be severe, the claim failed. The risk of injury was a minor one. If you're getting knocked over by a dog, one might expect bumps and bruises, but getting a serious fracture as a result of being knocked over by a dog was rare. The claimant's own animal behavioural expert had been knocked over 6 times by dogs, yet he accepted under cross-examination that he in fact never suffered a serious injury as a result of being knocked over on any one of those 6 times. The judge also rejected the Facebook study conducted by the claimant's animal behaviour expert. He considered it was wholly undefined in its terms and scopes. Therefore, being able to rely on a Facebook study conducted with your friends on Facebook is unlikely to be viewed as very good by a judge. The judge also rejected the Daily Mail articles of previous dog strikes. So this case shows the difficulty claimants face in proving dog strikes are likely to cause severe injury. Now, Menzies was a very informative case, and I definitely recommend reading the article that Jasmine wrote on this case earlier this year, which is on the Gatehouse website. Jasmine, anything else to say on that case, or what knowledge does a keeper need to have about the animal? I think you're on mute, Jasmine.
Sorry. I am on mute, gosh. So before we leave section 2.2a, it's going to be, in my experience, it's going to be difficult to successfully prove that a dog or that kind of size animal bumping into a claimant and knocking them over is likely to cause severe damage. You'll find that most experts will say, well, it may do, but it may cause a severe injury is not enough for the test. So it doesn't just apply to dogs, it could apply to lots of other animals as well. And often the temptation is there for a judge to see a way out of having to go any further with the Animals Act if they find that the case falls at the first stage. So it's interesting how in some of the cases which Emma mentioned, some of the cases that Henry's going to mention, this point was never really taken by defendants. Is the injury likely to be severe? However, it seems to have gained a bit of a groundswell behind it in more recent years. I think that's something that Henry's going to touch on, the riding accidents, and if he doesn't, I will. So let's say you've got over the section 2.2a as a claimant, and you've got over section 2.2b, which is the often argued part of the test about whether the characteristic of the animal is normal, abnormal, normal in certain circumstances. You've got past those. It's tempting to give up, but you can't give up because you still, as a claimant, have to prove the third part of the test, the 3-stage test in section 2.2. That's section 2.2c. And that provides that the characteristics of the animal, so the ones that we're talking about which are relevant to your case, whether it's a horse rearing or a dog biting, whatever, were known to the keeper or were known to a person who at the time had charge of the animal as that keeper's servant, or we would say employee, or where that keeper is the head of the household, an anachronistic term, and those characteristics were known to another keeper of the animal who is a member of that household and under the age of 16. So a nice, easy example of a defendant, owner of an animal and keeper having knowledge of the animal's dangerous characteristic is the case of Flack and Hudson. This is where a horse had the dangerous characteristic of bolting every time it saw some farm machinery, and the claimant was riding the horse at the time when it bolted, having seen a tractor, and she fell off and died. It was a nice simple case here on knowledge, the 3rd stage of the statutory test and the section 2.2, because the owner and defendant and keeper of the horse knew that this horse would bolt when it encountered a tractor, because the year before the horse had bolted while it was being led by the defendant's husband, dragged him down the road and left him with a broken leg. So that's a nice, clear example of some actual knowledge. But is that enough? does there have to be actual knowledge by a defendant keeper? Do they have to know all about their animal and these animals' particular characteristics? Well, no, the authorities have been quite clear that constructive knowledge will suffice. So let's take, for example, the seminal case, Mervahidi. The bolting horses escape from their field out on a dual carriageway at night, crash into a passing car. In that case, the keeper was deemed to have knowledge. There was really no argument about it because it was accepted that all horse owners will know that horses will bolt if sufficiently frightened, and that was the circumstances of that case. There was also constructive knowledge applied in the case of Welsh and Stokes, the Court of Appeal case, where the Court of Appeal looked at this third stage of the test and considered what degree of knowledge is required where a rider fell from a rearing horse, which had never reared before. She was riding along a road, so she fell on tarmac and suffered some severe injuries. The defendant said, this horse has never reared before. And they didn't have the requisite knowledge that the horse had the characteristic of rearing. There was expert evidence in that case, as you would expect, which said, well, all horses might rear in certain circumstances and times. And Lord Justice Dyson held that the knowledge of the general characteristics of horses to rear in certain circumstances was sufficient to satisfy the last stage of the test in the Act. There was no requirement that the keepers had to know that this particular animal would act in that way. However, you might think, well, that sounds simple then. It's not quite as simple, because in the case of McKenney and another against Foster, this was decided quite shortly after Welsh and Stokes. It put another gloss on this concept of constructive knowledge. This was a case where a calf had been weaned off a cow, and the cow was in a field, a big fence, and the calf was in a barn. And that night, the cow managed to clamber over somehow or jump a 6-bar gate. It went down a lane in the opposite direction to where the calf was in the barn, and then somehow managed to get across a 12-foot cattle grid onto the road. There was lots of suggestions of how the cow might have got across the cattle grid. Did she tiptoe over it? Did she jump it? No one really knew, but anyway, she got past it. When she was on the road, there was a collision between cow and the car passenger died. The court held that the cow had reacted in an exceptional and exaggerated agitation resulting from maternal instinct. So she was like an excited wild animal. And they said, well, yes, a farmer could expect that there would be a maternal instinct of a cow which might cause it to react unhappily to being separated from this calf. This cow had reacted in a completely exceptional manner, which wasn't normal, and it wasn't known to the defendant. Therefore, the defendant didn't have the requisite knowledge to satisfy Section 22C. In another situation, another case on knowledge, a case called Smith and Harding was a case where a horse kicked out while it was being clipped. This case failed for lots of reasons, but it was accepted that, although it was accepted that all horse owners will know that horses will kick in some circumstances, that's not the test. It's whether all horse owners would know that horses will kick out in the particular circumstances of the case. And in this case, there was an expert who is an experienced horseman who gave evidence he had never experienced a horse kicking out when about to be clipped, which were the specific circumstances of that case. Therefore, knowledge of the defendant and generally horse people was not made out. But very interesting, and this is the point which there's been a case on recently, which is heading off to the Court of Appeal. And I know that some of you here listening might be involved in that case, so you can tell me where I get it wrong in a minute. But the point is that knowledge doesn't have to be knowledge by the owner. It's knowledge of the keeper. The keeper may not be the owner, maybe someone else. And further, the statute provides that a keeper is fixed with knowledge of a dangerous characteristic of their animal, even if only their employee or perhaps their child knew of it. So the case I'm talking about is a case which I seem to read about in all the newspapers, Daily Mail included, which was the case of Ford and Seymour Williams. This is where the claimant was employed by the defendant as a groom to look after the defendant's horses at the defendant's premises. There was a cubbing meet and the claimant was riding Tommy, which was one of the defendant's horses, and the horse reared up, fell backwards on top of the claimant, caused her significant injuries. There was an issue as to why the horse reared up, because it died shortly afterwards. I don't think it even ever got back up to its feet. And the experts put forward two options. They said either the horse suffered a catastrophic internal injury like a heart attack, which this caused pain and anxiety to the horse and it reared up, or the horse reared unexpectedly for some other reason and the death was caused by its fall over backwards. The experts couldn't say which was more likely. After a lengthy judgment, the judge, which was Michael Kent QC, who I think was thoroughly fed up with the Animals Act come the end, he found it was more likely that the horse was reacting to a catastrophic internal injury rather than being disobedient. He said in any event, there wasn't anything to identify particular circumstances that could give rise to abnormal behaviour. So on the basis that the horse reared as a result of a catastrophic internal injury, he found that the defendant didn't have specific knowledge that this was something that could give rise to rearing, and it wasn't common knowledge amongst equestrians. He dismissed the claim. So the case has permission to appeal. That's to be heard in, I think, end of November or beginning of December. And there's many points in this case on which it's going to be interesting to see what the Court of Appeal have to say. But it seems to me that there may be a point here on knowledge. Having looked at the judgment, the judge found that the claimant was the defendant's employee. Remember, knowledge of a characteristic by the keeper's servant is enough to satisfy section 22C. Now, in the judgment, the judge considered the claimant's, the rider's knowledge when it came to consideration of, is Tommy just behaving badly? Which he didn't, the judge found that he wasn't behaving badly, it was this internal injury, but he didn't seem to consider it in the circumstances he found, which was that Tommy reared up in reaction to a catastrophic injury. He dealt with, did the defendant know this? Did equestrians in general know this? But if the evidence was, and I don't know what the evidence was because I wasn't in that case, if the evidence was that the claimant was aware that this rearing was normal in the event of a catastrophic injury, then it may seem that that point on the Animals Act, that knowledge point, may succeed at appeal. We will await the outcome, and I will await the outcome and no doubt write about it once it's been received. So that's my update on knowledge. Now, Henry, you're going to talk to us about riding accidents. Is it ever possible, Henry, to bring a successful claim for a fall while riding a horse?
I think nowadays, Jasmine, the answer to that is pretty unlikely. It seems to me that the wind is blowing to blow us back to what our forefathers would have seen as fairly standard. These riding accidents will happen, not forgetting the fact that they used horses day in, day out. And I think there's an underlying trend that courts are looking at when people fall from horses, that is something that a rider would expect. And accidents do happen. I'm afraid in those cases, the risk is one which the courts are increasingly saying that riders are taking on by themselves. And that brings me to the question of Section 5 and the statutory defences in the Act. And of course, the first one of those is a person is not liable under Section 2 that you and Emma have been talking about of the Act for any damage which is due wholly to the fault of the person suffering it. An example of that was given in the case of Mervahidi when Lord Scott said at paragraph 15 that if you stand behind a police horse during a riot and decide to jab its rear with a sharp object, then no one is to blame if it kicks you. And it's certainly the case that if you carry out a deliberate act and do something and you're aware of what the consequences will be, then there will be a defence. I should say that defence at 5.1 is more normally seen in respect of dogs rather than horses. although there is another case which involved it. It's a case of Jones versus Baldwin, which is an unreported one from Cardiff County Court, where the claimant was injured when he rode too close to the rear of the horse in front and was kicked. And it was deemed that that was wholly due to the fault of his riding too near to the horse in front, which anybody who rides horses should know that you shouldn't do. So Section 5.2 is a person is not liable under Section 2 of this Act for any damage suffered by a person who's voluntarily accepted the risk thereof. And this is the key that Jasmine was talking about. And example cases of this are the case of Turnbull, where the claimant, I think the horse called Jem, knew that the general risks of horse riding. And she also knew that the horse was working in a bitless bridle for the first time. It was doing so because it had a sore mouth, and when riding with a bitless bridle, it was accepted that horses had a greater freedom and would not respond the same as if they were under a normal bit. So the horse was ridden out, and on riding, she was thrown when she took the horse for a canter in an open field. And there the court found, and the Court of Appeal found, that she had accepted the risk and she knew it, and it was a general knowledge, and in accepting it, that the defence was made out. Similarly, there was an earlier case of Freeman versus Higher Park Farm. Again, the claimant riding a horse that was known to buck, but on the day did a particularly large buck. The claimant could not say that she accepted the risk of some bucking, but not all, or the accepted the risk of the one size of buck, but not another. Therefore, you accept a general risk, and she agreed. And again, the claim failed, and Section 5.2 was successful. There's a further case of Goldsmith versus Patchot. Again, the claimant fell off the defendant's horse when it reared up and started to buck. At the trial, the claimant abandoned her claim under negligence and only pursued the claim under the Animals Act. The judge found that 2.2a was satisfied, and 2.2b was satisfied. It was normal characteristic of horses to rear and buck in circumstances where they're startled or alarmed. And the judge also found it was known to the defendant, and so 2.2c was proven as well. However, the judge at first instance dismissed the claim on the basis of the statutory defence. This was because the claimant in cross-examination in that case accepted that there was a risk when riding a horse, any horse, that it may rear or buck if startled or alarmed. The claimant appealed, but on appeal, it was thrown out, and Section 5.2 succeeded again. These defences that, especially 5.2, is to counter the position in Section 2, in which general knowledge is all that is required to establish sufficient knowledge to be strictly liable. So it's the other side of I look at it as the other side of the coin. And therefore, equally, general knowledge is that that should be required to show that a claimant had enough knowledge to voluntarily accept the risk of injury. That is, for when defendants and claimants looking at these cases, one has to consider what the knowledge is and whether it has to be specific knowledge. This defence, though, the defence at 5.2 isn't available where the claimant is an employee of the keeper, as per Section 6.5. So when a person is employed as a servant, using the anachronistic term, by a keeper or an employee, and an animal incurs a risk incidental to his employment, he should not be treated as accepting it voluntarily. In terms of riding accidents and looking at the statutory defences, the statutory defence of Section 5.3, the trespass defence, is more applicable, I'd say, to guard animals and guard dogs and so on. But what I think is shown is that in the cases that we see coming through, and there's another case, the case of Lynch, 2017 case versus Ed Walker Racing. I think all these cases are showing that as it goes on. I think what the Court of Appeal in particular is seeing is that perhaps the Animals Act needs rejigging, not so much rejigging, but placing into perspective. And when people go out riding horses and so on, and it is now, I think, more the case that courts will look at it, and people who are riding horses, unless they're a child, unless there are specific factual reasons, it's more likely than not that a court will start with a position that people riding and going out riding have a general knowledge as to what the characteristics of horses are. Horses are well known as being flight animals. They aren't ones to stand their ground. They will run. They can be startled and spooked very easily. And I think this is generally accepted now. And of course, when you go, and I've had experience of this firsthand recently because my daughter's started riding. Now, when you go to a riding stables with little children and so on, there is a long debrief to start with as to the characteristics of horses and ponies, to make children aware to start with that they should never go round the back of a horse, that horses will fright and bolt at the most what we consider everyday things, even a sheep moving in a field towards it, or a car going past. Now I think the Court of Appeal and the courts are recognising that people who go on riding are voluntarily accepting that risk, because it's made so clear.
So despite all of this, Henry, you're still letting her have riding lessons?
Yes, she loves it. Absolutely adores horses.
If you, the British Horse Society have a standard form which they supply to riding stables, which any new rider's meant to fill in, which has a lot of this. I accept that riding is a risk sport. So, if a riding accident is going to be a very difficult one to prove under the Animals Act, I suppose there's still claims in negligence for riding accidents. I was put on an unsuitable horse. I was asked to ride an unsuitable terrain. Negligent tuition. I couldn't even do a rising trot, and then they took me out galloping. So I suppose those kind of claims still exist.
There is potential, and I know there are ones where they're taking on hacks and so on, and riding schools near us take horses on the beach, where horses may come into contact with dogs and puppies, and horses and dogs, unless the dogs are properly trained, don't often mix very well. And I think there are instances, of course, of, again, if they're riding along country roads and cars and vehicles, where you can have a potential claim for negligence if you're not given all the information that you require before getting on that particular horse. And
the point that you mentioned as well, that the defence of consenting to a risk isn't available for employees, that's an interesting one. I think that also came up in the Ford case that I was referring to, because if the horse was just reared up as a result of behaving badly, then potentially a defendant keeper could have the defence of, well, you rode it, you know what it was like, you took it out, you accepted the risk there of falling off. But because it was found in that case that she was an employee, that defence, even though the factual circumstances weren't made out there, that defence wouldn't have been available to the defendant because she was an employee. So an interesting interplay, really, in her status as an employee affects the defences that the defendant could run, as well as the knowledge point.
I think that makes common sense. The Act may be opaque and not particularly well drafted, but I think one part of it that is clear is that bit, which is if you're an employee, servant, in anachronistic language, and you're required, that's part of your job, the defendant can't say, well, you've accepted the risk, because you have to, that's part of your job.
Cool. Okay. We're at 2:29. So does anybody have any questions they want us to see if we can answer? You can either put something, I'm looking at the chat box, so there is a chat box if you want to put it there, or you can unmute yourself if you want to.